We will hear argument first this morning in Case 15-214, Murr versus Wisconsin. Mr. Groen.
Mr. Chief Justice, and may it please the Court. The fundamental unfairness in this case is illustrated by one fact. If anyone else in the world, other than the Murr siblings, owned Lot E, that owner could sell or develop it. But the Murrs cannot.
Mr. Groen,
let me ask you this question, and it's a hypothetical. It's not this case. Suppose that 3 years from now, lots such as these, two lots in the same ownership, become immensely more valuable than the two lots singly. Each lot singly would be worth $100,000, but these lots where you can build a bigger home are worth $500,000. The county wants a fire station, and it takes Lot E. What do they pay for it under your theory?
They should pay for compensation for the taking of Lot E.
Which is $100,000. So under your hypothetical, property owners stand to lose $300,000 under my hypothetical. And your answer?
No, I don't think so. Under the hypothetical.
The hypothetical is together they're worth $500,000. Singly they're worth $100,000 each. What is the amount that the county has to pay to take Lot E for the fire station?
The analysis must begin with defining the relevant parcel that's the subject of the takings analysis.
And under your view, that's Lot E only.
That's right.
And they pay $100,000 only, that's it.
The landowner would have the burden of proving that there are additional damages that they should be compensated for, but the presumption—
You can't get it. There's no severance damages. You're taking the entire parcel.
You're taking all of Lot E, and they should be paid compensation for Lot E.
That's
$100,000,
and so under your theory, landowners, in the hypothetical that I put up, would lose money, and the state would be getting a windfall.
If that hypothetical does not include any integrated economic use between those two parcels, that is correct. The compensation is determined by the lot that is taken.
But the integrated use is determined by the market. Your theory, it completely ignores market factors.
And that is exactly what the government would argue, is that the compensation must be limited to the parcel that is taken. And in eminent domain law, which is the hypothetical that you're providing, in eminent domain law, the presumption is exactly that. Compensation is limited to the parcel taken, unless that presumption can be overcome by the landowner proving that the two parcels are actually there's a unity of use between the two.
Well, why isn't that true here? Then why doesn't that defeat your theory here?
It supports the theory. It's the exact same principle, only in reverse. Rather than the government limiting compensation to just the parcel taken, here the government is saying we want to combine the values of the two in order to find there's no taking. But in both scenarios, you have to begin with the presumption of determining what is the relevant parcel that is subject to that analysis. In both scenarios, either eminent domain or inverse condemnation, you have to begin with a single parcel.
Can I ask just a clarifying question about your argument? Because one of the things that makes this case odd is that there are family members all around. Both sellers are the same family and the buyers are the — but if I'm right, your argument would extend in the exact same way to a situation where you have two sellers who are completely independent of each other. Mr. Jones and Ms. Smith have nothing to do with each other. Another buyer comes in, also has no relationship with Mr. Jones or Ms. Smith, and that buyer would be able to make the exact same argument that the Murr family is making in this case. Am I right about your argument?
Well, I'm not sure which parcel your hypothetical is talking about.
You have two pre-existing substandard parcels. Somebody comes in, buys both, but all the parties are independent of each other.
Each parcel is grandfathered.
And now the person who has bought these two substandard lots wants to build on them, and your argument would be the exact same.
That's right. They're each independent, discrete, and separate parcels. And the grandfather clause that is attached with this land use ordinance would protect the development and sale rights of each parcel independently.
So where does a state's regulatory power come in? Justice Kagan put in a hypothetical. Two one owner owns two parcels or two different people own two parcels and they sell it to your one owner, and the one owner knows the regulation says if you have two contiguous land pieces, you can only develop on one if they're both below an acre or whatever the rule is. Your rule would just do away with your expectations as a buyer.
Well, no. In that situation, the fact that someone might know that there are regulations on properties does not change the time of the taking. The taking occurs in 1975 when the regulations redefined the property rights, and that redefinition of the property rights does not insulate.
But the parents, it may have been a taking for the parents, but they never charged it. The children, when they took, were subject to the regulation, and they knew it. And they could have said, no, I don't want two contiguous ones, Dad and Mom. I'll go buy the next-door lot from someone else.
And this court in Palazzolo versus Rhode Island ruled that the notice that the Murr children may have had, they actually didn't know, but let's assume that they did know.
They should have known.
Let's assume that. Let's assume that beyond should have, they actually knew. Palazzolo stands for the proposition that the subsequent heir or a buyer does not lose a takings claim. The state is not absolved of liability.
That's a very different situation. In Palazzolo, all we said was that if the seller has a takings claim, it's not extinguished just because the property is transferred, that the buyer could have the exact same takings claim. But the Murr children are not asking for this. They do not have the same takings claim as the Murr parents did. Isn't that right?
No, I think that's not right. They have the exact same takings claim because we're talking about Parcel E and the rights that inherently—
The parents could develop on Parcel E. The children can't.
The parents, if they had put it in their own common ownership, which they did for a period of time subsequent to 1975, there is a takings claim there. It's the rights inherent in the property. And in each of these, in all of these scenarios, you have to go back to define.
For the parents, let me try this again. For the parents, the two properties were two properties. It's only when the property becomes one property that this takings claim arises.
The takings claim arises because of the restrictions imposed by the government, not by change in ownership or anything like that. The change in ownership does not change the nature of the property interest. That's the key part of Palazzolo, that if you take away the takings claim or redefine property interests, you're actually changing or altering the nature of property. And that's where we come back not to a takings analysis, but to defining the relevant unit of property to apply the takings analysis to.
I'm sorry.
No, follow up.
The regulation here, the only thing that it affected for the Murr parents and for the plumbing company was their ability to sell to a buyer who wanted to combine these two lots. That was the only thing that was affected. Isn't that right?
Well, the parents didn't seek to combine these two lots or to sell to someone who wanted to combine the two lots. The parents owned both parcels. They had one in the plumbing company name. They eventually put that in their own names as well in 1982, after the 1975 restrictions were in place. That didn't merge the parcels. There hasn't been a merger here. Merger is simply a term that describes what happened, and that is that the use restrictions preclude the independent sale or development of Lot E. That is the gravamen of the takings complaint.
And we're told these merger rules have a long history. Many states have them. So why isn't that background state law that would apply?
There are lots of land use regulations of all types, including merger provisions. We do not have a background provision here, a background principle, because you can't have a background principle that applies to one person but not to another. If someone else owned Lot E, they can develop it. So it's not a background principle to say that this only applies to the Murrs. Same thing in the neighborhood. This is the St. Croix Cove subdivision. There's over 40 developed residential lots here. There's nothing about building a home on this property that rises to the level of a nuisance or something that takes the right to use the property out of the title that is that
Your
property.
answer to Justice Ginsburg is that all of those other state regulations are also invalid.
No. Those regulations are fine, whatever they may be, and they come in all types of forms. The question here is what unit of property do we utilize for determining the takings analysis? Once you determine that, then you determine, okay, under that merger law or whatever land use ordinance, does it reach a level of magnitude of interference that there is a taking? And those would have to be analyzed on the merits of their own
I
situation.
thought your argument was that under state law, the properties were not formally merged, that the merger was only, I think as the Court put it, an effective merger.
That's exactly right. There has been no formal merger. These remain separate legal lots today. This term merger has been used very loosely, and all it really means is that the Murrs' right to independently use and develop Lot E has been destroyed. They could actually still give it away.
I'm sorry. Do we know exactly how Wisconsin and the county define common ownership? For example, if one lot is owned by an individual in that person's own name, and then the adjacent lot is owned by a wholly owned corporation or LLC, is that considered to be common ownership? Or if one lot is owned by, let's say, 4 siblings and the other one is owned by only 3 of the siblings, would that be common ownership?
Under the way Wisconsin has applied common ownership, as long as they are not informally the same name, so here William and Dorothy Murr, they fully owned their plumbing company, and so they were technically in different ownership, and that was enough to be in separate
Would it be enough if
So,
a husband owned one, wife owned the other? That's different? That's separate?
The way Wisconsin has been applying it, it would encourage that kind of manipulation and bring in incentives.
I mean, I've not got beyond Holmes. Holmes says that a regulatory taking violates the Constitution, unless it's compensated, when it goes too far.
Correct.
All right? Now, what you want us to do is to put some pretty clear lines in that word too far.
No.
And my problem is I can't think of just what those lines should be, that perhaps there are many different circumstances and many different factors. For example, in your case, I imagined that what the state was concerned about is they want to preserve a lake. At the same time, people own some property around that lake, and they used to be able to build houses. So here's what they say. You can build one. One. And it doesn't matter if you have 6 lot parcels knocked together or one. One is what you can build, because after all, this Constitution is concerned about, to paraphrase Justice Warren, protecting people, not rocks. And so we look at the people and say, how does this affect them? And in this case, you have a case, but there are some factors against you. And the Federal Circuit and other opinions of ours have avoided drawing clear lines. Well, you see where I'm going, and I just want your general response.
Yes. This case does not address the merits of whether there is a taking. This case first has to deal with the threshold question of what is the relevant unit of property.
And that's what I'm objecting
parcel?
to. See, now you're not getting my question, because my question is, why look for that? Is it relevant? Yes. Is it determinative? No. If we start making determinative rules, developers will take 500 acres, they'll break them down into 500 different properties, state perhaps aiding in this, 500 different ones, 3 of them will be just wetlands, and they'll say, see, you took my 3. When actually he started out with 500, and it wasn't a big deal. You see the kind of problem they're written about in the briefs. I want your general reaction.
Well, the general reaction is you must begin with the approved legal lots of record that have actually been approved and that have attained, because they're legal lots of record, they have rights that are secured. That's what Roth is all about.
One of the oddities of your position is that you seem to be taking half of state law. In other words, you're saying, well, there are these lot lines, and everything has to depend on the lot lines because they've been legally approved. But there have been other things in this case that have been legally approved, too, and one of them is this merger provision. And you seem to be saying, well, we look to state law for the lot lines, but then we ignore state law for the question of when lots are merged. And why should we do that? If we're looking to state law, let's look to state law, the whole ball of wax. In other words, saying, well, when I buy those 2 lots, they're really not 2 lots anymore. According to state law, they're 1 lot.
In defining property interests, Roth and this Court in Lucas Note 7 both recognize that you look to the state law, not to the whole body of state law. You look to the state law that governs the creation, that's the legal recognition of lots and the protection of the property interest.
Well, let's say I think that you're right, Mr. Groen. It's like the legal recognition of property. But the legal recognition of property has something to do with lot lines, and it also has something to do with when lots are merged, when 2 lots are merged into 1. And why would we ignore that question of merger?
There's 2 reasons. One, they have not been merged. And that's the point we were discussing earlier. They have not been formally merged. But
I don't know.
2,
what would it take to be formally merged?
Elimination of lot lines. And
why?
That has not happened.
Right.
Because
court,
they remain.
The state can say we don't have to eliminate lot lines. All we have to do is to say that the lot lines don't have legal effect for some purposes.
And it's only for the limited purposes of precluding sale or development. But more than that, your question comes right back, it circles right back to Palazzolo, where you really have to define property interests by the rights that are already in place that secure benefits. That's what Roth stands for. That's what Lucas footnote 7 stands for. And Palazzolo points out the principle that you cannot then go forward and say, oh, well, the state has redefined
this. Again,
this.
I think Palazzolo depends on the buyers having the exact same takings claim as the sellers, which it seems to me does not exist in this case. But let me ask you a different way around the question, which is whether you think reasonable expectations matter at all in your framework.
The reasonable expectations that were addressed in Lucas footnote 7 are the expectations that grow out of the traditional understandings of property law. People understand when they buy a lot in a subdivision that they are buying a lot that has a right of use, that has a deed, it has geographic boundaries, and that's what they're relying upon.
If I'm buying property in this area, I also know that there are these rules about when you can develop on substandard lots and how it is that contiguous lots are understood for purposes of that development potential. So why aren't I buying subject to those pre-existing regulations? In other words, this is not a regulation that just happened to me when I was an owner. I'm buying subject to, and property is a bundle of sticks. We know that, right? First year of law school. And I'm buying, certain metes and bounds, but I'm also buying into a certain set of things about what I can and can't do on the property. So why isn't that perfectly consistent with my reasonable expectations? I'm supposed to know the zoning regulations, and when I buy a house, when I buy a piece of land, I'm buying subject to the pre-existing zoning regulations.
I understand the use of reasonable expectations under the Penn Central for determining whether there is a taking. But here we have to first determine what unit of property. Is it Lot E or is it Lot E and F combined? And in that situation, you have to look at the creation of the property. Property is property, and it doesn't change.
True. But what about, of course, property is property. But we are still dealing with a provision of the Constitution that in the regulatory area is designed to prevent takings that hurt somebody unreasonably. It goes too far. So why isn't what you want to look at one thing to look at? But we might look at others too. We might look, for example, at whether the individual who bought that property at the time he bought it knew about this restriction. We might look at how overall he is hurt in any related way. We might look, for example, at the kind of need that was there. And we might see 2 big questions. One big question is, though it's awfully general, is he being treated unfairly either because we're forcing on him the whole cost or a lot of the cost of something that benefits many, many others, or because we are interfering with investment-backed expectations? I mean, as you read the cases, it seems to me there are a set of factors like that. And my problem with your argument is it wants to take one and then apply a kind of mechanical test.
No, it keeps coming back to the task is to first define the unit of property. The Murr parents have two separate distinct lots. Each is a lawful legal building site. And if owned by anyone else, it remains a lawful legal building site. Under the restrictions enacted in 1975, it went from two building sites to one building site. That is what has been lost.
May I ask a question? I do think, as I'm reading all the briefs in this case, that the issue is how much weight should we be giving to the state boundary lines, the state property lines. You say, as a denominator on the takings claim, it's fixed. You use the word presumption in your brief, but you haven't explained to me what overcomes the state boundary line, property lines. So I don't think the word presumption has any meaning in your brief. Others, like St. Croix and the government, and embedded in Justice Breyer's question, thinks the denominator should be a more nuanced calculation, although St. Croix, Wisconsin, and the solicitor seem to have a different weight to that. So let's start with, is yours a fixed presumption? Does anything ever overcome it?
Yes.
Or is it under every circumstance the denominator?
You must begin with the presumption of identifying the single parcel. And nobody, as you point out, no parties. And that presumption is overcome if you have facts that are sufficient to show in fairness and justice that the individual should bear the burden. And an example we can draw straight out of eminent domain law. If you have a hotel owned by a person, and they own the parking lot next door. They're two separate parcels, and government is going to condemn the parking lot. The parking lot is used with the hotel as an integrated economic unit. The presumption in eminent domain law is the same principle here. Government is taking only the parking lot, and they will argue we only pay for the parking lot. The burden then shifts to the property owner to prove that the parking lot is an integrated part of the operation of the hotel.
So what's the difference between that and the factors that the other parties are using that says, look at how the property's been used over time? Here, the family has a house on one parcel, a volleyball court and a barbecue storage area on another. They use the other parcel, house on one side, the other parcel as access to the beach. The house has not had an economic value to the children. It was there. They're using it. So what's the difference?
I think you have an inaccurate visual understanding of what the parcel is. Lot E, and this went up on summary judgment, is a vacant parcel. There's nothing on Lot E. It is its own independent parcel. The Murrs will sometimes walk across it or maybe play volleyball on it, but it is not an integrated economic unit as in the hotel parking lot and the hotel. In that situation, you can overcome the presumption, and that landowner in that situation will argue that they should be paid compensation.
Well, why isn't it an integrated unit? Because they have a barbecue. In other words, your hypothetical.
They don't have a barbecue.
Whatever they have. But,
volleyball
court. Under your hypothetical, if the hotel was on Lot F and the parking lot was Lot E, what would be the fair value if the state took Lot E for a firehouse? How do you figure out the fair value? Don't you figure out the value of that on the market to a buyer, not the loss to the seller because he's next door? It has to be.
The rule begins with paying for the parking lot, and the burden is on the landowner to show that that person should get additional compensation for the impact to the hotel. That's where that combination
just can't be if they're separate lots. That's not the law in any state that I know.
That's the unity of use rule that is in condemnation all the time.
But that's when there's a single parcel.
No, that's when they're two separate parcels. It's the hotel and parking lot example.
Well, then under your view, the landowner wins either way.
It depends on...
If the value is great, he gets the double value. If the value is smaller, then he can sell the lot.
There has to be, in that example, unity of use. So, for example, if the parking lot and the hotel, they were just different parcels, and the parking lot was serving some other property and the government took that parking lot, there's no damages to the parcel with the hotel, and the landowner would not be entitled to anything. It's the same
we won't get
principle.
But you're the one who's insisting on on the lots being treated separately.
I'm insisting on the same presumption that you begin the analysis by identifying the relevant parcel. Here, that has to be Lot E. It was purchased separately. It's a separate deed. It was purchased for separate purposes. And it is the lot that is regulated.
We begin the analysis. What more is there if you're saying we isolate E, and E now is of no value? It can't be sold. It can't be built on. What is the consequence of saying we identify parcel E? Is it the same as if the government physically took parcel E?
It's not a physical taking, but it may have the same practical effect.
Yes, that's
because the value of Lot E is diminished from $410,000 to $40,000. There's a 90% decrease in value.
But there is some use that can be made of this of the property.
Lot E cannot be developed on its own. That ability has been taken away.
Yes, but if the combined properties are sold,
but
it's going to be a much bigger price tag than if just F were sold.
But the question is, the Murrs began with two building sites on separate properties. That was taken away. The value that you're talking about is the value that comes from being able to build. Well, the Murrs already have a house on Lot F. So when you say what is the value afterwards, the better methodology is how much would the Murrs or someone who owned Lot F with an existing house on Lot F pay to add land to it? How much would they pay to add Lot E to their existing building site? Now, what they do with the property...
Let me give you an example which might help me. Let's go back to Holmes' case. There's 100 acres. There are 50 columns of coal to hold up the ceiling. That, he says, is okay. No compensation. But wait. Suppose instead of one person owning all 50 acres, suppose 50 people each own 1 acre. And in some cases, the column runs through the acre, and some it doesn't. Does that make any difference?
That hypothetical is not analogous to this situation.
I don't care if it's analogous or not analogous. I'm trying to get my thinking clearer, and oddly enough, different things make my thinking clearer, and this may be one of them.
The analysis has to begin by defining the parcel of property that is regulated.
In your opinion, if in the Holmes case, instead of one person owning the whole 50 acres as one lot, there would have been 50 people who each owned an acre. Now, it looks the same, the columns are in the same place, etc. And you're saying that does make a difference.
If someone...
Yes or no?
It does make a difference, and the key is to look at the parcel of property that is owned by an individual, and is that property being taken away?
So the usual
There's two
way,
questions here.
The usual way, Mr. Groen, or at least a frequent way in which this comes up, is a developer buys 100 acres of land, and that land is split up into 101-acre parcels, and let's say 15% of them are on wetlands and can't be built on. It makes an enormous difference whether we're going to say that those 15% are independent lots, because if they are, then the developer comes in and says you have to pay me for all of that. But if they're not, the developer is out of luck because it's only 15% of the whole. Isn't that right?
The beginning part of your analysis says the developer subdivided. The developer cannot subdivide without government approval. And when there's a subdivision that is created under the laws of that state, then rights attach.
Yes, well, the subdivision has occurred with government approval, and the merger provision has occurred with government approval, saying that this shouldn't be understood in the case of substandard lots as independent.
The merger provision is like the wetlands provision. Both restrict use. And then the question then, once you've identified the relevant parcel in your hypothetical, the question is there a taking of that 15%? The burden would be on the government to show that that 15% of the lots is actually part of an integrated economic unit as a whole, and then you proceed under a takings analysis. But in both situations, you must first define the relevant parcel. Unless there are further questions, I'd like to reserve the remainder of my time for rebuttal.
Thank you, counsel. Mr. Saitlin.
Mr. Chief Justice, and may it please the Court. I would like to begin, Mr. Chief Justice, by answering your question, or the point that you made. The lots here have merged for all relevant purposes under state law. It is true that the lot line between Lot E and Lot F still exists, but that has absolutely no continuing legal relevance under state law.
Your point raises my exact concern. You said for all relevant purposes. The question is what purposes are relevant. And it seems to me that what purposes are relevant is analysis under the Takings Clause. And we all know the issue, I think, that